Okay, Judge Kennedy, you may proceed with the program.
All righty. Well, everybody, welcome to another section in our program on video and legal decision making webinars put on by the Science and Technology section of the American Bar Association. My name is Rod Kennedy. I'm a retired judge of the New Mexico Court of Appeals, an occasional professor of scientific evidence. And today, the topic is video and open source investigation and legal advocacy, which talks about how video is used in court cases and how things are collected and archived. And we have some leading experts in that field. The person who's putting this series together is Dr. Sandra Rostovska, who came to us having received a fellowship and backing from both the Andrew Mellon Foundation and the American Council of Learned Societies, looking for a home for this video evidence program, and came to us. And we in the Scientific Evidence Committee of the Science and Technology section of the ABA thought it was absolutely fascinating and that we ought to back it. And so far it has certainly been that and more. And this program today has an awful lot of folks who have done it all. Just incredible things. And I think we'll have an awful lot of fun and hear some very thought-provoking things. So Dr. Rostovska, it's all yours.
Thank you so much, Judge Kennedy. And I would just like to welcome everybody to our session on video and open source investigation and legal advocacy. For those of you who have been following the series, the first two sessions were much more around the science behind visual information processing and visual interpretation. And now we'll get to hear from some of the people who are at the forefront of using a video in innovative ways in the pursuit of justice. So we'll hear from Jeff Deutsch, who is the co-founder of the Syrian Archive and currently research and program director at the nonprofit organization Mnemonic. Jeff has been at the forefront of thinking about how do we make use of the multiple videos that are coming from war and conflict zones like Syria, and really use them effectively into investigation, preserving them, and then using them as evidence in court. And Syrian Archive has had successful use of evidentiary material in the case of Syria, both in court in France and Germany. We'll then hear from Alexa Koning, who is the executive director of the Human Rights Center at the University of California, Berkeley School of Law. The Human Rights Center was winner of the 2015 MacArthur Award for Creative and Effective Institutions. And Alexa and her team at the Technology and Human Rights Program have really been at the forefront of the open source investigation. And they have put together the Berkeley Protocol on digital open source evidence, of which video is part of. Quite innovative, thinking about video's use in the international criminal space. And last but not least, we'll hear from Alex Dickinson from JK Global, a visual litigation firm based in California, who has been thinking about creative and effective uses of video as part of the litigation process, whether to use video as part of presentation of cases or as evidence. And they've done amazing work in both criminal and civil courts. And they're famous for their work also in the Derek Chauvin trial. So without further ado, I welcome our guests for today. We'll hear short presentations from each of them for about 10 minutes, and then we'll have plenty of time for questions in the end. Thank you so much. And Jeff, on to you.
Perfect. Thank you so much, Sandra, and thank you so much for organizing this amazing series. I'm just getting my screen set up. Very good. Okay, great. Can you see this?
Yes.
Perfect. Okay. Yeah, no, so thank you again so much for having me. It's great to be here with Alex and with Alexa. Um, I'm just going to briefly introduce more of the archival aspect of the work. So talking about some of the types of content that we're working with within, open source investigations as a civil society organizations, going into some of the methods in which we're using for some of the tagging and annotation, and then talking a little bit about some of the things that we're able to produce as a result of this. I think it connects quite well with some of the other presentations that are going to be coming soon. So my name is Jeff Deutsch. I'm a research director with an organization called Mnemonic. And is this going? Yes. So before I go into what we're doing at Mnemonic, I just want to quickly say how we got to the place where we are. And our story starts in about 2014 when we began archiving open source human rights documentation emerging out of the conflict in Syria. This was coming because we were seeing lots of content being produced at the time by civil society organizations, by individual journalists, by media houses, right? But we were seeing that a lot of this very important documentation was being taken offline, right? So we quickly realized that we need to develop independent infrastructures to preserve this outside of the social media platforms which they have been uploaded to. And this was extremely important in the Syrian context, like other closed societies, which I can talk about in a few moments, because we didn't have the ability of international organizations, international monitoring groups, NGOs, journalists going in and reporting on what was going on. So these open source records became very important because it was, in many cases, the only way that we would know if certain crimes were being committed, where they were being committed, and who is being, involved. Since that time, right, in terms of scale, for Syria, we have about 4 million records that we've been able to archive, but we also expanded our mandate and used the similar kinds of technical infrastructure, methodologies to work on archiving at-risk open source materials in other conflicts regions like in Yemen, Sudan, and more recently in Ukraine, which recently launched its first investigation. So I'm going to talk about the type of content that we work with. We're mostly working with digital content, right? We're mostly working with online open source content. And within the context of this presentation, we're mostly looking at audiovisual content, right? So video, things like YouTube videos or Facebook videos or videos that are embedded in tweets or other kinds of platforms. Generally, it's user generated, although not in all cases. We might see content from defense departments, for example, right, who upload to their own channels. And generally, it's non-testimonial. In some cases, especially in regions where maybe bandwidth is a little lower, like Yemen, we rely more on text-based posts, as well as testimonial information in the form of interviews that we are able to identify. We don't do interviews ourselves. So in terms of the workflow that we use going about this archival process, we have this model that starts from collection, goes into preservation, processing, verification, and investigation. And I'm going to talk about the first three in particular, because I think the last two are an aspect that Alex and Alexa are able to speak more to within this context. In terms of content collection, what we're talking about really is finding the stuff that we want to be preserving, right? So this might involve activities like monitoring on a daily basis what's going on the ground, how are borders shifting, which kinds of actors are in which kinds of places. This might allow us to identify new potential sources for preservation of materials. And of course, we do investigation-specific discovery. For example, if we're working on a data set around attacks on hospitals and medical facilities, we might be looking for specific incidents and specific content relating to these incidents. Content preservation and automated processing happen simultaneously. Within our infrastructure, there's a tool called D1 that we have developed in-house and maintain in-house. And so this preserves content that we're able to discover on multiple servers in different places, as well as doing some kind of automated processing like hashing and timestamping this material, storing these hashes and timestamps with independent third parties for data integrity purposes, and maybe I can get into that in a little bit later, as well as extracting more technical aspects like file size, date of creation, and things like this. L4S is our user interface for viewing this content. So this is a screenshot of what one of this investigations might look like through the L4S platform. And this is where we view and annotate. Annotation, when we're talking about annotation, I'm going to let Alexa speak to the Berkeley Protocol because she's, of course, much more of an expert on this than I am. But we're trying to annotate content largely manually, looking for information that might add observable characteristics or context, right? So we tag at multiple levels. And if we think of the media records at the bottom, and in yellow, we have the content tags. These are observable characteristics. You might have multiple sets of observable tags for each piece of media. If, for example, a video is filming two different incidents and they're spliced together. Or if, for example, you are looking at to develop a database on chemical attacks and also on medical facilities, and there might be an overlap. So you might have multiple sets of these content-based tags. What's important is that these are describing only what you can see or what is within the content itself. And then in red, we have more incident or thematic contextual tags, right? So sometimes you can tag these observation level tags into a higher level of more thematic, right? We can look at, for example, are there bodies being gathered or bodies present, right? And by aggregating these together, you might be able to identify, for example, indicators of use of force. And so we do this tagging for three different reasons. The first is for usability purposes, such as verifiability, which I'll let Alexa speak to a bit more. But also, even if some piece of content might not be admissible within an evidentiary setting, it might be reliable, right? So we assign confidence ratings to these records because you might be able to use a piece of record for more contextual information. The second reason is for usefulness. And so these are for the observable elements or tags. And the third is for significance and context. When we look at these records in aggregate, we might be able to describe and establish a pattern. And this significance and context in particular, and discovering different types of patterns might introduce the possibility of introducing pattern evidence, especially within a legal environment. This might, for example, if done well, allow for base crime patterns, criminal intent, proportionality, or the identification of indicators of lesser documented crimes, and of course more. So I want to give something concrete to tie this to. And last year we worked on a database on attacks on hospitals and medical facilities in Syria, and we identified 410 attacks on hospitals or medical facilities for which we were able to find and preserve open source documentation. We used a variety of circumstantial indicators of intent to tag this content based on, for example, whether there were repeated attacks, whether the sites were known to parties, whether they were clustered, showed characteristics of targeting and others. And with this kind of tagging approach, we see the developing of a data set based on this open source user-generated content useful for case scoping and case building efforts. Different jurisdictions have different rules on admissibility. By narrowing this down and creating filters, we allow for lawyers to be able to go into the content, find and extract particular incidents that might meet their specific criteria. In terms of what this looks like publication-wise, there's a variety of ways that we might share some of this content. This incident, for example, is public, or this data set is public. It's viewable at the link that's here, medical.syrianarchive.org, and I can drop that below. But we don't publish everything. We also might share privately different type of information if we have a request based on a media request or a request from a prosecutor or an accountability mechanism, for example, as well as provide external access to the archive for selected partners or groups. So I'm going to stop there, but I'm more than looking forward to all of the questions and discussions from the following panelists. Thank you so much.
Thank you so much, Jeff. And Alexa, on to you.
Great, thank you so much. As mentioned, I'm Alexa Koenig. I'm at UC Berkeley School of Law. I'm a huge fan of Jeff's work and all the innovation and effort that's been put into really thinking through how do we preserve some of this really ephemeral content, but deeply valuable content that's increasingly showing up in online spaces. So as Jeff mentioned, I'll give a little bit more of the international perspective on this. I'm going to go ahead and share my screen. And let me get some of these Zoom features out of the way. So what I thought I would start with is actually a definition. Jeff had mentioned digital open source information, and a lot of what I'm going to talk about for the next 8 or 9 minutes is going to be focused on this content that has been uploaded to the internet that can be accessed by any member of the public. One of the ways that we define that category of information that might feed into evidentiary purposes is that it's also information that any member of the public can access either through observation. By that, we just mean you go to a search engine like Google, you put in your search terms or your hashtag or other data, and you observe what is produced. Second, by request. There are obviously some times where you cannot access a website unless you give them, for example, your email address. And that is essentially a form of request to get access to that information. Or ultimately purchase. I think in the development of this definition, there was a real need to include things like media subscriptions, say to the New York Times or the Washington Post, where it's information that most members of the public can access, but would have to do so for oftentimes for a nominal fee. So it doesn't include information where you need some kind of special status to get access. So if you need a subpoena, you need to be law enforcement, that would not be considered within the definition. It also doesn't include any information where you would use any illegal activity to get access. So for example, hacked information would not be considered public information. There is a lot of conversation happening right now in the space about how we should think about hacked and leaked documentation and how that can come into different jurisdictions for evidentiary purposes. As Jeff mentioned, one of our big projects over the last many years has been developing something called the Berkeley Protocol on Digital Open Source Investigations. That was a response to a growing recognition that so much information today is coming up online that may be valuable to investigation and case building. I'm going to talk a little bit more about what that includes. One of the challenges that we were seeing in the mid-2010s, as people were beginning to realize that the volume of online digital content related to legal investigations was growing, was that there was a lack of consensus around even terminology in the fact-finding space. So we hosted a workshop to bring together technologists, investigative reporters who were really leading on some of the methods for effectively and efficiently mining online spaces for potential information. And then also lawyers and investigators who were thinking about how this information could be presented in court and what its potential evidentiary value was, to talk about what is this phenomenon that we see increasingly exploding. And one of the things we really needed to do was we spent an entire day, I thought it would be about 1 or 2 hours, trying to get at a definition of what is digital open source information. It ended up being 8 hours of just getting to 5 definitions. But one of the useful things that I think really came out of that process was recognizing that digital information, ultimately for legal purposes, can be bracketed into 3 different buckets. There's the information that we find online that can be used for intelligence, essentially for decision-making about where to go look for other forms of evidence, who might be helpful witnesses, how we might want to craft our investigations plans, et cetera. A second bucket of lead information that will lead to other evidence. And then finally, the evidence itself, stuff that might help to prove the elements of disparate crimes. This, of course, is a reflection of the evolution of open sources. Lawyers and others have been mining open sources for relevant information forever. I think we've certainly seen the evolution from print through photography, through to information that was shared over radio, and of course, with the digital turn in information sharing, stuff that we can find through the internet, through the proliferation of the smartphone across the globe, et cetera. The volume is staggering. So I think one of the challenges, of course, for the space has really been figuring out, how do we deal with the volume? If you have over 1 million people logging into Facebook in any given internet minute, if you have over 500 hours of video being uploaded as an estimate to YouTube every minute, how do we comb that? And I know Jeff can talk about this further in ways that help us bring this extraordinary volume down to some form of human scale. I think another real trend that we've seen in the space is, whereas, in previous, I work mostly in the war crimes investigation space, so the international context, but whereas we saw, a particular platform really being dominant in information sharing about, say, Myanmar being Facebook, or Syria and YouTube, we're seeing this information increasingly spread to a wider and wider array of platforms that legal investigators, that lawyers need to know how to comb and mine efficiently for relevant data. Another big change in the space has been, since 2000, the commercial ability to access satellite imagery that used to be within the purview and control of governments. What we've seen is a rising accessibility of satellite imagery and a dropping of costs. And I think when we're thinking about the visual building of cases, what we're often thinking about is, what can we get relevant to a case from the ground level? So the ground perspective, like that which we'd capture with a smartphone, to the overhead level, what we would see from, say, a drone-like perspective. And then third, this bigger overarching level of satellite imagery that helps us to put different incidents or the unfolding of a particular incident into geographic space. The sources are extraordinary. I think one of the biggest things, we train hundreds of war crimes investigators and other lawyers and human rights investigators every year. One of the biggest things that I think we find a lot of people who are new to the space don't always realize is just how little information they're actually getting when they say go and use a search engine and they put in their key terms to try and find out if there's relevant information. Some of the statistics that we've seen is that there's the surface web, the information that you're getting, that is the data that's been indexed by search engines by those companies. That's only about 4% of the information that actually exists on the internet. And it's that 4% that I think we all are becoming increasingly comfortable with getting access to. The deep web is a much larger bucket of about 90% of the internet. And that's where a lot of really rich sources for legal case building and fact finding can be found. That's the information where you need to know how to get to it, can be really helpful. And I think that's one of the things that we're often training people on, is how to work with the deep web. And then, of course, there's the dark web, which is approximately another 6%, where you need specialized software, the Tor browser, to actually get access. And I think that's something that our team does not regularly work with, but is becoming increasingly relevant to issues around trafficking, drug processing, et cetera. So some of these sources that we've really seen, video streaming sites, thinking about how those come in to help with information, and of course, things like property records and geospatial platforms, social media, et cetera. One of the challenges, though, that we have also seen with this turn towards visual information, and I know this was talked about a bit in an earlier session, are some of the biases that, as we build out digital investigations plans, have to be thought through. One of the most critical is access bias. Who actually has access to the internet, who may have been witness to a crime or may have additional information to share, and who doesn't, whose voices are missing. Thinking through human biases around interpretation of visual information, which I know Dr. Rostovska has covered in earlier sessions. And then third, of course, the machine biases, knowing how computers, how algorithms operate, and how that limits what you can see, but also the ways that you can set up your working environment to help counter some of those biases. Jeff also mentioned verification. One of the challenges for all of us, of course, is the quality of the information environment from which we're trying to find relevant and trustworthy data. We all know about the risks of deep fakes, of misinformation, stuff that's been mischaracterized. That was probably when I started working in this space, one of the most shocking things for me is just how often someone would say a photograph was of X when it was actually of Y and was recycled from earlier places and times. One of the things that we strongly recommend in some of the resources that we've pulled together for lawyers who are working with this material is the need to really go through a 3-step verification process for every piece of visual imagery that you may be wanting to rely upon in your investigation. So that first step is to look at the technical data that may still be attached to a photograph or a video. Is there metadata that helps to establish the time and date on which something was captured? Is it possible that that information has been manipulated? Does this give additional clues to location, et cetera? And the second is content analysis. So really evaluating within the 4 squares of that visual imagery, is what you can see consistent with what you have been told, and what information is actually present that can be helpful for either proving elements of a crime or leading you to additional witnesses or other sources of information. And then finally, and this is the piece that we find is often underutilized, but incredibly critical, is source evaluation. So, when we're talking about information pulled from online spaces, oftentimes those sources may be anonymized or have be pseudonymized. How do we know who this person is and how reliable they are for the kinds of information that they're purporting to share? Our work in this really did come from the legal context, and I'll kind of speak a little bit quickly through this and tie this up. We started working with the International Criminal Court back in 2011, 2012, as we recognized that a lot of the more traditional methods of fact-finding, while still equally relevant to cases in the 21st century, that there was a new bucket of information that was going to become increasingly relevant and was starting to become relevant. How did we better prepare the Office of the Prosecutor to find that information in online spaces, to preserve it, as Jeff has mentioned, and Mnemonic's been a key player in helping to develop those protocols. And then how do they potentially analyze that information and introduce it into court? And these are just reports from 4 of the workshops that we hosted in partnership with them, also bringing in people from the Department of Justice in the United States, the FBI, and others who have really done some interesting work in thinking through this digital turn. We launched an investigations lab in 2016 to go ahead and start training students from around the world through the law school, but also through legal studies and undergraduate programs in how to do some of this digital information and it's talk about its relevance to international criminal process. And today we work with 3 different sets of fact finders. So international lawyers and investigators. We also work with investigative reporters, and then finally, human rights researchers. For the sake of time, I won't go through each of these cases, but there are 5 different contexts here. We have the MH17 investigation. This was one that was looking, the Bellingcat in particular, and the Dutch forensic team were looking into on a plane that was shot down over Ukraine in 2014. There was just a decision, and there was just the decision in the case, I think a couple of days ago, a little bit earlier this week. That was a milestone case in that it really demonstrated and showcased some of the power of bringing together these visual materials for fact-finding and how lawyers could be using that to help build cases. And today, of course, in the context of Ukraine, we're seeing that explode. The Berkeley Protocol, we pulled together in partnership with the United Nations Human Rights Office and more than 100 people with whom we consulted around the world. We also hosted several workshops to deal with emerging areas of law and practice. Ultimately, this provides some guidance as more and more lawyers and investigators turn to this digital area of fact-finding on what kinds of challenges need to be thought through in setting up that office and that investigation. It's largely principles-based, which means that we give the foundation. Every team has to ultimately come up with their own standard operating procedures that incorporate the exact tools that you'll be using for each of the processes that we outline in the protocol. And that's something that we've been increasingly working with fact-finding teams around the world on developing. Finally, and I'll wrap up in the next minute, I think 3 of the resources that can be really helpful from the Berkeley Protocol is in the back. There are a series of annexes that help you think through how do you even analyze the digital landscape relevant to your case? What are some of the questions you should be asking? Some of the content you should be gathering? How do you do a digital risk assessment? When we go online to do fact finding, we raise new vulnerabilities and risks for ourselves, our clients, and for the communities that have been impacted. How do we make sure we don't walk into this blindly? And then how do we develop an online investigation plan to pull together all that digital data that will feed into our investigation lifecycle? And then how do we present this in courtrooms in ways that can have greatest impact? And I'm happy to talk more about that later. I'm going to skip over this one for the sake of time. There are a number of new outputs. C2 Research, Forensic Architecture have been increasingly working with both legal investigators and investigative reporters to find new ways to visualize this information and to maximize its impact. And then finally, I'll land on two projects that we're working on that I think may be helpful for people to know about. One is a project that we've worked on with Mnemonic and others, looking at the need for a digital evidence locker of some kind. Mnemonic obviously is preserving quite a bit of content around specific conflicts. How do we think about the need to preserve this information when particularly graphic information may disappear from online spaces relatively quickly? And then the other project, which I have depicted on the left, that's a picture, a mural of George Floyd, is a book that I'll have coming out with a colleague called Graphic early in 2023 that looks at the psychosocial toll that dealing with large quantities of graphic imagery can take on legal teams and some of the tips and tricks that have been developed for minimizing the harm and maximizing the value of working with this subset of imagery. So with that, I'll stop sharing. Thank you.
Thank you so much, Alexa. And Alex, on to you now.
All right, thank you so much for having me. Excited to be speaking here. What I'm going to be covering is more of the domestic use of content and video sources in litigation presentation. Specifically the George Floyd case, that is a matter that we worked on, obviously utilizing the infamous video that was taken and then also CCTV information. So what I will do is go ahead and share my slide deck here and get started. And when it comes to video, and again, Alex from DK Global, and I'm the senior visual consultant here. And this is a lot of content that we go over with the attorneys that we work with, because we work on cases across the nation, we've done some international as well. We do criminal, we do civil, we do all different types of legal matters, and we just most recently did the George Floyd case, but also the Alec Baldwin reconstruction animation. If you Google Alec Baldwin recon animation, you'll see it come up everywhere. It was released out, and we actually worked with some individuals in the room and recreated the whole sequence of that shooting because there was lack of content. Funny enough that they actually had a camera in the room, but it wasn't rolling, so they didn't have footage there. So we filled in the gaps of information using 3D animation, and I'll get more into that. But in a domestic sense, and really in an international sense, you have sources of available content everywhere. I mean, everyone has a phone. So everyone walking around could be a potential source for capturing content. We live in a society right now where people are so content motivated when it comes to influencers, when it comes to pretty much anyone who has a phone. If an incident is taking place, the motivation to film it versus just being in the moment and watching it is surpassed more times than not. People want to capture that moment via phone. So also when we are doing video, when we're dealing with video that's being captured, it can now become evidence. So whenever there's any kind of police activity that is going on, a lot of the times you will see phones out. And I think it's done a lot of good things because there's a lot of incidents that are happening that would not be have its time in the light of truth if it wasn't captured on video. Now, there's so many different ways to utilize that video in the litigation process, but before it even gets to litigation, it gets posted on the various different sites, Twitter. There's so many different sources where people are posting this content where it can be found. And so Jeff and Alexa went over that a little bit as far as kind of that source content. And what we're finding is that they're now coming forward, and they're being able to be identified much sooner in the litigation process, we're able to actually authenticate and utilize these sources in the litigation process. So now let's get to the infamous, George Floyd matter. This video was captured by a 17-year-old high school student. And what was fascinating about this case is that there was so much different content and so much different CCTV footage, but it was this one video taken by the 17-year-old high school student, Darnella Fraser, that ended up being the crux of the investigative purposes for us. We were watching this case unfold just like everyone else, and we, of course, just sadness, disgust, all of these things that were built up inside. As we were watching this unfold, I was seeing the news, the actual press conference from the attorney, Tony Romanucci, who was talking about they were filing a civil lawsuit. I know Tony from some previous conferences that we've been to, and I reached out, and I knew, because there was a lot of different things going on as far as what happened, how it happened, what did he die from, and we didn't know the specifics yet because we didn't have all the facts and the data. But I knew that it was imperative that we were involved in the case, because there's things that the video doesn't show, or there's ways that we can present the video to really find out what happened here. Because I think that's what everyone was starved for. And I think what most users and most viewers are starved for is what happened. We want answers as far as what went on inside of his body. What were they thinking? Were they out of protocol? Were they in protocol? So it was very interesting that the video that I really believe changed the use of video in litigation, and people now wanting to film these interactions, it was taken by a 17-year-old high school student. So when you have bystanders around, I mean, they could all very easily turn into content witnesses and then essentially become on the stand. And that's what happened here. Darnella was filming because, in her own words, she didn't believe she was going to be able to communicate what was going on later to friends, family, and whoever else, and them believe her of what was going on. She did not think they would believe what she was telling them. And then we also have, another user, another person who was capturing that content that ended up being a witness on the trial as well. So being aware, if you're in the litigation process when it comes to criminal, civil, all different types, to really comb through and find on the different sources and platforms, search hashtags, all of the different things that Jeff went over. Those are all different ways to find out if there is available content that really helps you tell the story of what the truth is, what happened. Because perception is reality and with everyone. So, you may have two different people standing there and they saw different things and they recount different stories. So we want to get as much of that video content and cross-reference it. And that's what we did in this case. So she films the video. She posts it at 8 o'clock at night that day on Facebook. And then by the next day, it goes completely viral. And now it's on the news. And now this video that the 17-year-old girl filmed is now at the center, really internationally. It's becoming an international incident of, brutality and what happened here. And what I found interesting, I was just thinking about this when I was putting this presentation together, is how it says leaked video. I think leaked video, there's no leaked video anymore. Now it's just video, because it is much more common to have video content surface of an incident when it comes to any kind of police activity, any kind of incidents. Just so many people are filming and posting content right now. The term leaked seems 2019. It seems like it is, we have now graduated into a state where this is just how it is now, and that everything is being filmed. There is available evidence and captured footage of an incident, more likely than not, and it's no longer leaked. It just is. This is now the video content. She then is now on the stand. So this 17-year-old girl who took that video because she didn't think anyone was going to believe her, now is on the stand in the criminal trial for Chauvin, walking through what she saw, why she saw it, and she was a great witness. I watched the criminal trial. we were involved in the civil matter for the family, for the estate. So I'm going to be going through that presentation a little bit as well. So what we do here at DK is we utilize visuals and demonstratives, especially 3D animation, to enhance or further inform or augment activist and bystander surveillance video footage, CCTV footage. And it has proven to be a very effective tool in filling in gaps and giving context, because different videos without context can really tell a different story, a different vantage point, a different angle. All of these things really factor in to a decision by a jury or by a council to render a settlement, or a city. And in this case, it was the city of Minneapolis who were able to reach the settlement of $27 million based on the litigation. And this is actually happening during the criminal trial. So what we want to do is take that visual data and we want to build a educational platform with that, where we're building graphics and video and just walking, or animation and walking you through to render out an action. And that action may be a verdict, it may be a settlement, but ultimately what we want that action to be is a catalyst for change, to change something different, to protect the sanctity of human life and people's rights and human rights in the most basic way. So I am going to now share the George Floyd presentation that we did. I'm not going to go through the whole thing in the interest of time, but I am going to go through and kind of talk about some of the tactics that we did use. Starting from the surveillance video, that is where, the CCTV and the bystander footage is where we started. We had to watch that probably 50 times. It was very hard to watch, but then working backwards, we started thinking about protocol. Okay, so what was the protocol here? So one of the first things we did is we started out with the Minneapolis Police Department's own website, where we're walking through, and now we're identifying their actions in the video. Are they following their own protocol? So what we wanted to do is start with the presentation of their own website. Before we even get to the incident, what is the Minneapolis Police Department called to do? What is their service? And it is to protect and serve in a way that minimizes harm to our community. Did they do that? We didn't believe so, and I don't think anyone believes so as well. So we were able to walk through and again put some context into the video before they're even seeing it, which is, are they even acting in a manner that is appropriate for their title and for their position and authority? They have an authority to use deadly force. Did they violate that? So that was the first thing that we wanted to do. Then we wanted to identify the individuals involved. Now, it was tactic to use the mugshot videos, because we wanted the viewers and the everyone who is viewing this presentation to understand and to know that these people are now, they're in trouble. Like the criminal process is moving forward. They are being charged. This is not under dispute that they were acting on their own accord and out of policy. So then we go through and we talk about, again, this is their own use of force continuum. We want to talk about the specifics of lethal force versus officer presence, level 1 to level 6. Where did they fall in these levels? Did they follow the right protocol in this video? So before we're even getting to the video content of the CCTV and Darnella Fraser's bystander footage, we're building a narrative of this is what's expected of these police officers as they approach an incident like they did in the Floyd case. So this is the CCTV footage. And again, just utilizing certain things with little windows to identify and highlight, it is all effective to draw the attention to the viewer. So we start with the CCTV footage. Then we go to the bystander footage that is behind vehicle. We identify the 2 officers that were involved previously. So we're identifying them already in this footage, and we're using a combination of the CCTV graphics, photos to really tell the story. So now here's the start of the incident, and we're walking through specifically, what's going on. As you can see right there, he's automatically, Officer Thomas Lane is automatically already reaching for his gun. So Floyd isn't even out of the car yet. They haven't even identified if he is a threat. So obviously right now we're building the sense that there is a anxiety and possible fear-driven action from these officers as they approach the scene. So that is what we want to do as we walk through this incident. So as they walk him over here, they walk him over to the side and they're speaking with him. You can see that he's distressed, but it's more of an anxiety attack that we believe than the delirium narrative that they have put out. So they're speaking with him, he's in cuffs, and that's when they walk him across the street. Now, this was an important shot as well, because now you have 2 officers on scene, you have 2 more showing up, and you have Derek Chauvin and Tao showing up. We wanted to show Tao in context, he's got 11 years of experience. In that 11 years, he has 6 complaints and a brutality lawsuit in 2017. 11 years on service with 6 complaints and a brutality lawsuit, you know, that should he be under review? Should he, like, what were the, it gives you pause on, okay, this is not somebody who's been on the force for a long time and really had 0 incidents. And this one, honestly, when I found out this information, it was astonishing. Chauvin, 19 years of experience, 17 complaints, 3 shootings, 1 fatal. My immediate reaction was like, how is this guy still a police officer? You know, he's had so many complaints, he's had shootings, one of them was fatal. So obviously, whatever the makeup of the fabric of who Chauvin is and how he conducts his police work, it can result in conflict, obviously. Now, I'm not saying that officers don't have a hard job and that a lot of their dealings result in conflict, but when you have complaints, 17 and 19 years, that's almost 1 a year, 3 shootings, 1 fatal, that should give you some pause as far as just, and it identifies just what type of police work that individual may do. Okay, so now we have the Darnella Fraser videos. We're walking through this. So what we wanted to do is identify the specifics because it was a little bit grainy. So we do a little pause and then we identify with graphics to identify where Chauvin is, Quang, and then Officer Lane. Because really, as we dug into the medical, all 3 officers had a hand in the medical suppression of Floyd's breathing and the block of blood to his brain that, you know, resulted in his becoming deceased. So that's what we wanted to identify, is where they're at as we're walking through this. So again, we're pausing and we're identifying, hey, here's where these individuals are at. So now we go into a 3D realm. And again, this is where we come in and the rubber really meets the road for us as a visual presentation team. And we work specifically, we utilize height and weight. We do character models that have similar likenesses to the individuals. We do laser scans if needed, and we work with the medical examiner on this one. So what we wanted to do was focus on Chauvin. And as you can see, he's putting that pressure on his neck. Now, the biggest question that was going on at the time of what happened is what was going on inside of his body. And I'll try and get through this quickly so we can get through the Q&A, but what was going on inside of his body? That is where the 3D components are just so valuable, because we can't see X-ray vision and see what was going on inside Floyd's body. But what we can do is rely on the medical evidence and the expert opinions of the medical examiner, who can give us that direct information as far as what he found. And what we found is that the carotid artery, bilateral carotid arteries were being suppressed, okay? So that knee on Floyd's neck is not only hindering his breathing, but it is not allowing oxygenated rich blood to go up to the brain to where his organs can continue to operate and he can continue to think, breathe. I mean, the brain is the most important organ of the body, and they are suppressing the oxygenated rich blood that is coming up to that. So that's Chauvin's knee that is doing that, and the pressure that he's putting on there. In conjunction with that, when you have non-compressed lungs, you can see that your lungs are moving, they're breathing, they're pulling in oxygen. And one thing that is also very interesting is the diaphragm. Your diaphragm sucks oxygen in. So if your diaphragm is compressed, it's not just your lungs doing all the work. Your diaphragm acts as almost a vacuum to pull your lungs and pull that oxygen into your lungs so you can breathe. So when it came to what was happening with Quang and Thomas Lane, in conjunction with the bilateral arteries being compressed, we were able to go in and identify that because of the suppression there, his diaphragm is now suppressed. Not only is his diaphragm suppressed, he's got the knee on his neck, and he's got somebody who's holding his legs and his hips down, so he can't pivot to try and give his diaphragm some room to pull oxygen into his lungs and continue to breathe. So we were able to show all that with the medical evidence to show that because of the pressure and the forces that were involved, that, you know, he was not able to sustain breath and continue to get oxygenated rich blood into his brain, keep his heart pumping, and then ultimately, you know, survive this incident. So we've identified what's going on medically. It's not fentanyl, it's not the exhaust pipe. He is medically being executed at this point. Then what we wanted to do is cognitively walk through the time. It felt like forever that he was under this type of pressure. Using the clock, using different cognitive. Yellow is a yellow light. You know, it's something to be aware of. It's not stop, it's not go, it's something that gives you pause. So that color we wanted to identify, like, hey, this is a pretty serious situation and cause for concern. So as we're walking through this, we wanted to then show how long it went, what the actions were, and then ultimately get into the red clock. Now we're getting into mission critical status. He is not breathing anymore. He's not showing any signs of consciousness, and Floyd is still putting that pressure on his carotid arteries, and he is now not getting blood to his brain. He's not breathing. We are in a very serious state right now. So the red clock gives you that it's stop. It is a cognitive color that the brain automatically associates with hazard. So that's what we wanted to identify there. Again, just walking through the whole incident, and now it starts to get into the black, because now the black is ultimately it's death. It's too late at this point, and very unfortunately. So, and there's some key points in here that we wanted to identify as well, is that during this whole sequence, you look at Chauvin's his conduct, and he is not one who is concerned for the well-being of Floyd. So when it came to the criminal prosecution, I think they got it right. And, you know, they rendered a, you know, obviously massive amount of judgments and hate crimes, and they weren't able to, you know, he's probably going to spend the rest of his life in prison for that conduct. So I'm going to wrap up here, but what I wanted to do is just walk through some of that presentation. If you want to see the full presentation, I'll put my email in chat so I can send it over to you. It is graphic, but I believe it's very important that it was out there, because it identified what we couldn't see, what bystander video couldn't see, which was what was going on medically inside George Floyd's body. And we coupled that with CCTV, several different cell phone videos, and the bystander footage to really tell the story, the truth of what happened. So that's what we do here at DK Global. Again, we're working on we worked on the Alec Baldwin case to shed light on what happened there, the rounds and the gun. If you're interested in that presentation, again, if you just Google Alec Baldwin animation, the full presentation is pretty much everywhere. So feel free to do that. Yeah, I'll now turn it back over to Sandra, and appreciate y'all letting me speak.
Thank you so much, Alex. And I'm sorry to rush each of the presenters. These were all fascinating talks, and we could go on and on, but we're trying to get some questions and discussion. So I already received, I asked people to post their questions in the chat. So we have several questions. So what I'm going to do, I'm going to ask them all at once. And because we have 6 minutes left, I'll ask the panelists to address them, but as briefly, succinctly as possible. And then the panelists, please feel free to share any resources, links to databases, videos, protocols, documents in the chat function. So a question for Alex that came in the chat: if you're motivating by wanting to be a catalyst for change, does that create the potential for a bias for the site for whom you're working to result in the case? And should that bias be part of the explain context for the presentation? For example, saying this is what we believe. And then another question for Alex is, how much do you have to take into account potentially prejudicial impact of reenactment or animation content? For example, in the Trayvon Martin case, the animated reenactment was not allowed as evidence, but was allowed as illustration to accompany closing arguments. Do you ever have to make decisions that shift how you might otherwise present the animation because of potential prejudicial impact? And then a question for Jeff and Alexa, can you talk a little bit about the challenges with the removal of videos and other content from social media companies, and also some of the things that you've been doing and experimenting to analyze content and scale, given the many types of videos and other information you're collecting for each of the investigations you've been working on?
Got it. Yes, and I'll try and get through those pretty quickly. So when it comes to the prejudicial impact, obviously that's something that we have to take into account. And that is ultimately something that is up to the legal teams, and it really just depends on what side that we're working on. In the George Floyd case, specifically, it was about what happened medically. Prejudices aside, it is the medical fact. That's what we always try to understand. And there's cases that we will get involved in where we end up not doing an animation, or we go a different direction because it's not in the realm of physical possibility or medical possibility on what that case is, what that side is saying happened. With George Floyd, that's what happened medically. That is specifically what happened. That presentation was utilized for settlement purposes. Things are a lot more sterile when it goes into trial. So when it's trial, it's very sterile. I can guarantee you those components would have been it wouldn't have been evidence. It would have been a demonstrative exhibit, probably used in closing argument. When it's evidence, it is very sterile, and we utilize components that are very clipped. And meaning like it is just the facts. It is just, hey, here's the medical evidence of what happened based off of, what happened inside of his body. So we do have to, make decisions on what's to animate and what to illustrate. But essentially that is coming from the experts and the legal teams. Medical experts, biomechanical engineers, accident reconstruction engineers, those are really the individuals. It's their expert analysis and opinion, and it is the fact and evidence that we have, which comes in the form of video. So obviously we try to be persuasive in storytelling for the side that we're representing, but when it comes to trial, it is very different because obviously it's, a very strict set of facts when it comes to trial testimony, and a little bit more leeway when it comes to closing arguments. So I hope that answered those couple questions. And again, I'll put my email in chat if you have further questions.
Thank you. And Alexa or Jeff?
I think since we have very little time, the one thing I would just say is we're seeing some really interesting new ways of using machine learning processes around object recognition and natural language processing to try to comb huge data sets. And I'll punt to Jeff so he can talk more. The other thing I'm really interested in watching that I think is emerging is the use of virtual reality, and also the use of demonstratives to interview witnesses, which I think can have very positive application, but can also have very biasing effects. So I think there's a whole body of research beginning to come out on that front.
And I got the permission to go 2-3 minutes over time. So Jeff and Alexa, take your time to explain these things.
Perfect. So super quick, then I'll just mention the machine learning aspect, which is we've been working since about 2017 with a project called VFrame on doing object recognition. We have millions of records, so trying to search through this manually is not going to happen within a lifetime. So we are now searching for munition remnants, and we will be next year publishing a database on cluster munition remnants using some of this machine learning object recognition methodology.
And maybe a time for one last question from the audience.
And just to fill a few seconds here, I did see the other question, the background information about the officers and their previous misconduct being allowed into trial. It depends on the legal arguments. It does show a pattern of aggressive behavior. So that can be, it really depends. It depends on the judge. It depends on motions eliminate. It depends on what sides. But really what comes into play in trial is to identify if this individual has a history of violent behavior or out of policy and protocol behavior.
And on that note, it's 12 o'clock. So I just want to thank our panelists for this amazing presentation. Please follow up with the resources that they all shared in the chat. The recording will be available online after the session, but I also want to take this opportunity to invite you to our session on deepfakes on December 2nd, to be followed by a session on forensic decision-making on December 9th. That's the webinar that we had to postpone. That was supposed to be last week, but we had to postpone. And then we'll wrap up with a seminar on police body camera on December 16th. So the next kind of 3 weeks in December, we have amazing programming, and we all invite you to join us for those. And a big thanks to Lionel Delamora, who is behind the ABA logo, who has made sure that this webinar series runs smoothly and has done all the logistical side of things. So thank you, Lionel, so much. And thank you again to Judge Kennedy, who's been an amazing host for the series and my residency. So I hope we'll continue the conversations. You have the speaker's contact information in the chat. You have my information, so please feel free to reach to all of us. We would like to keep talking about these issues.